The judicial system of Turkey is defined by Articles 138 to 160 of the 1982 Constitution. Civilian and military jurisdiction is separated. While military courts usually only try military personnel, they can also try civilians in times of martial law and in matters concerning military service. Turkey has a law system, which has been wholly integrated with the continental European system. For instance, the Turkish civil law system has been modified by incorporating elements mainly of the Swiss Civil Code, the Code of Obligations and the German Commercial Code. The administrative law bears similarities with the French counterpart and the penal code with the Italian counterpart. The legal profession. The general term for members of the legal profession in Turkey is hukuk. In Turkey, any man or woman, after having graduated from a law faculty at a university, can become a avukat, hakim or yargıç, savcı or notar after terms of internship specified in separate laws. However, for the judges and prosecutors, before getting the title of training judge, they have to pass through a written exam which is held by OSYM and an interview carried out by a committee mainly consisting of judges. Lawyers. Private lawyers spend 1 year of internship and then join the Bar Association and the Turkish Bar Association. All Turkish lawyers are required to wear black robes in court. Judges. The Turkish court system does not recognize the concept of a jury. Verdicts for both criminal and civil trials are reached by a judge or usually a panel of 3 judges, who have to base their verdicts on the law and their conviction. A judge is also a law school graduate and can be one of the following: criminal judge, civil judge, administrative judge. The criminal judges serve at a penal court. These courts are separated into Ağır Ceza, Asli Ceza, and Sulh Ceza. The civil judges serve at civil courts of first instance or at civil courts of peace, while administrative judges serve in administrative courts. The Supreme Council of Judges and Public Prosecutors deals with the admission of judges and public prosecutors of courts of justice and administrative courts into the profession. Appointments, transfers to other posts, the delegation of temporary powers, promotion to the first category, the allocation of posts, decisions concerning those whose continuation in the profession is found to be unsuitable, the imposition of disciplinary penalties and removal from office. After the constitutional amendment which took place 2010, the composition of the High Council of Judges and Prosecutors was completely changed. It currently consists of 22 members. 10 members out of 22 are elected among the judges and prosecutors by their colleagues working in first instance courts, while 5 members are supreme judges elected by other supreme judges. 4 members of High Council are appointed among lawyers and law professors by the President of Republic and 1 comes from Judicial Academy. Minister of Justice is the President of High Council and the Under-Secretary of the Justice Minister is also an ex officio member. In the existing system, the High Council of Judges and Prosecutors has its own secretariat. In addition, the Inspection Board operates under the authority of High Council. Prosecutors' public charges are brought by prosecutors. Their full title is Prosecutor of the Republic and they have a Chief Office of Prosecution. Prosecutors are also divided into branches regarding their area in laws, similar to that of the judges. The Supreme Council of Judges and Public Prosecutors deals with administrative matters concerning judges of the administrative and judicial courts, and public prosecutors who are not members of the Court of Cassation or the Council of State. In the Country Report on Human Rights Practices in Turkey in 2006 it was stated, the High Council of Judges and Prosecutors was widely criticized for undermining the independence of the judiciary. The Minister of Justice serves as chairman of the 7-member High Council, and the Justice Ministry Under-Secretary also serves on the council. The High Council selects judges and prosecutors for the higher courts and is responsible for oversight of the lower courts. The High Council is located in the Ministry of Justice and does not have its own budget. While the Constitution provides for job security through tenure, the High Council controls the careers of judges and prosecutors through appointments, transfers, promotions, reprimands, and other mechanisms. Civilian justice. The judicial system is composed of general law courts, specialized heavy penal courts, military courts, the Constitutional Court, the nation's highest court, and 3 other high courts. The Court of Cassation hears appeals for criminal cases. The Council of State hears appeals of administrative cases or cases between government entities, and the Audit Court audits state institutions. Most cases were prosecuted in the general law courts, which include civil, administrative, and criminal courts. In 2004, Parliament adopted legislation providing for the establishment of regional appeals courts to relieve the High Court's caseload and allow the judiciary to operate more efficiently. Judicial courts. There are 2 forms of judicial courts. The peace courts are the lowest civil courts in Turkey with a single judge. There is at least one in every district. Its jurisdiction covers all cases assigned to the court by the Code of Civil Procedure and other laws. The civil courts of first instance are the basic courts. Their jurisdiction covers all civil cases other than those assigned to the peace courts. There is one in every city and district, and sometimes divided into several branches according to the need and necessity. Criminal courts. Even though the penalties are no longer divided into light and heavy sentences, the criminal courts still are named according to the penalties they were entitled to pass. Penal courts of first instance are courts with a single judge deciding on minor cases. There is one in every city and in every district, sometimes divided into several branches according to the need and population. The heavy penal courts consist of a presiding judge and 2 members with a public prosecutor. Offenses and crimes involving a penalty of over 5 years of imprisonment were under the jurisdiction of these courts, of which there is one in every city. But it is sometimes divided into several branches according to the need and population. State security courts. Under the 1982 Constitution, the then military government established state security courts to try cases involving crimes against the security of the state and organized crime. It would also act as a domestic tribunal to try cases involving genocide, crimes against humanity, and war crimes. The DGMs began to operate from May 1984 and replaced military courts which had been in operation during the martial law period. They existed only in 8 provinces. In April 1991, the law to fight terrorism entered into force, and cases involving crimes against the security of the state were now punishable under this law. The panel of 3 judges in each DGM included a military judge. As armed forces officers, such military judges remained dependent on the military for salary and pension, subject to military discipline and therefore not independent of military control. In a number of cases, the European Court of Human Rights has found the presence of military judges in the state security courts to be a violation of the fair trial principles set out in Article 6 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. In June 1999, the then Turkish government removed the military judge from the bench. In the context of a package of reforms to the Constitution passed in June 2004, the DGMs were formally abolished. The DGMs were transformed into heavy penal courts, authorized to try only cases involving organized crime and terrorism. In cases of state security, genocide, crimes against humanity, or war crimes, the military discipline courts would take over. Since the entering into law of a new criminal procedure code on 1 June 2005, the official name for these courts has been heavy penal courts. Most of the cases heard in these courts concern cases of political prisoners. Supreme Courts: the Constitutional Court, the Court of Cassation, the Council of State, the Military Court of Cassation, the Supreme Military Administrative Court and the Court of Jurisdictional Conflicts are the Supreme Courts mentioned in the judicial section of the Constitution. The Constitutional Court: the basic function of the Constitutional Court of the Republic of Turkey, established in the 1961 Constitution, is to examine the constitutionality, in both form and substance, of laws and decrees with the power of law and the rules of procedure of the Grand National Assembly of Turkey. Other functions of the court are as follows. With the capacity of the High Tribunal, the Constitutional Court judges the following: the President, members of the Council of Ministers, members of Supreme Courts, the Chairman and members of the Supreme Council of Judges and Public Prosecutors and of the Supreme Council of Public Accounts, the Chief Republic Prosecutors and the Deputy Republic Chief Prosecutors for crimes related to their officers. It audits the finances of political parties. It examines NAT decisions to revoke the immunities of deputies, or to dismiss members of Parliament. It chooses the chairman and deputy chairman of the Court of Jurisdictional Conflicts. The Constitutional Court is composed of 11 regular and 4 substitute members. Decisions are made when the 11 members convene. The decisions of the Constitutional Court are final. These decisions cannot be amended in any manner and their application cannot be delayed. Currently, the head of the Turkish Constitutional Court is Mr. Hasan Kilik, who holds the title President of the Constitutional Court. The Court of Cassation: the Court of Cassation is the last instance for reviewing rulings and judgments rendered by justice courts, criminal courts, the examination courts, and renders verdicts upon appeal. The opinions rendered by the Court of Cassation are taken as precedents for legal rulings in the first instance courts throughout the country, so that uniform application may be achieved. It is also able to modify its own ruling upon request. The Court of Cassation is divided into civil law and penal law chambers. As of April 2007, there were 21 civil law and 11 penal law chambers. The highest judge, who holds the title First President, is currently Ali Alkan. The Court of Cassation also has a chief public prosecutor, who is currently Abdurrahman Yalçınkaya. In case of indictments against political parties, the chief public prosecutor of the Court of Cassation appears before the Constitutional Court. Turkish Court of Accounts: Turkish Court of Accounts is Turkey's supreme audit institution charged with auditing, on behalf of the NAT, all accounts related to the revenues, expenditures and property of government departments financed by general and subsidiary budgets. No applications for judicial review of its decisions shall be filed in administrative courts. There's a debate on whether CSD is a Supreme Court, or even a court in the strictest sense. The Turkish constitution is said to contradict with itself by not listing CSD amongst Supreme Courts in Articles 146 to 159 while allowing no appeals to most of its decisions, effectively giving it Supreme Court power. Administrative justice: administrative courts exist at provincial level. The next instance are regional administrative courts. Administrative courts solved cases involving probate, bankruptcy, and citizenship matters. Tax and family law were handled in separate courts. The highest administrative court in Turkey is the Turkish Council of State, or equivalent to a federal supreme administrative court such as the Conseil d'État in France or the Federal Administrative Court of Germany. Its president is currently Hulusi Karakulluk. The court also has an advocate general, who is currently Mevlut Çetinkaya. Military justice: the military court system exercises jurisdiction over military personnel and during periods of martial law. The duties are described in Article 11 of Law 1402 on martial law of May 1971. Further details are laid out in Articles 11 to 14 of Law 353 on the foundation and criminal procedures at military courts of October 1963. The military court system consists of military courts, a Supreme Military Administrative Court, and the Military Court of Cassation. Military courts have jurisdiction to try military personnel for military offenses, for offenses committed by them against other military personnel or crimes committed in military places, or for offenses connected with military service and duties. Under martial law, military courts are competent to try all offenses that led to the announcement of martial law. Article 14 of Law 353 describes the offenses to be tried at military courts in time of war. According to Article 2 of Law 353, the courts consist of 2 military judges and an officer. In cases involving more than 200 defendants, the bench has 4 judges and 1 officer. Military prosecutors will be appointed according to the need. Judges and prosecutors hold the title judge along with their ordinary officers' ranks whether they are on the bench or prosecutors. In military courts, there rarely are defense lawyers to the accused, although the defendants are entitled to legal counsel from military personnel with the title Askari Hakim. It is also a court of first and final instance with jurisdiction over certain military personnel, stipulated by law, with responsibility for any specific trials of these persons. It has a president, usually a brigadier general, and a chief prosecutor, usually a colonel. Military High Court of Administration. The Military High Court of Administration, or the Supreme Military Administrative Court, has jurisdiction over military personnel in administrative cases or active military service. Its organization is similar to that of the Military Court of Cassation. Note that military courts and civilian courts do not act as subordinates to each other. They are independent from each other and should be immune to political influence. Also note that military courts are exceptional and are only available in military restricted areas. Court of Jurisdictional Disputes. The Court of Jurisdictional Conflicts is the final authority to settle disputes concerning verdicts and the competences of the justice, administrative or military courts. This court is made up of members of the Court of Cassation, the Council of State, the Supreme Military Court of Appeals, and the Military Administrative Court of Appeals.